I'm Ramsey, and it's almost 20 minutes past 1 in the night, and I'm here to give you an analysis of the workshop, which I promised. So basically, when you look at this workshop, it's headed Postgraduate Bar Course 2024, stroke 2025, Term 1, Week 2. Then, of course, there's the logo of Law Development Center and Department of Postgraduate Legal Studies and Legal Aid. The Postgraduate Bar Course 2024-2025, Module 1, Term 1, Week 2, week of 30th September to 1st October. I think this one is very clear and it needs no further explanation. So we have civil litigation workshops and we have the introduction. So they are saying that during the module, students will be exposed to interviewing clients, formalizing instructions, drafting pleadings for the complainant, and institution of civil suits. So this is basically an introduction, and the keywords I can explain here is they talk about interviewing clients. So basically, when the PA talks about interviewing a client, he wants to test your general knowledge. For example, I'm assuming you are in a law firm and the client finds you there. How do you treat him or her? So of course, I assume that as a normal student, you will first greet the client. First try to develop some rapport, ask him what are his or her names, and he tell you. Then after that, what have you come to? Do you have an appointment with counsel? No, I don't have, but I have the matter. So you begin to ask questions from the client and getting information from the client that's going to be relevant to establish the case or his problem and find a solution. So it's a normal conversation we always have with our usual friends, only that this conversation is targeted to get facts and see how we can apply those facts and at the end of the day advise the client. Then formalizing instructions, we are going to also look at that. When we talk about formalizing instruction, this is like an engagement letter. Basically, when a client gives you instruction, then you have to draft what you call an engagement letter. And an engagement letter, I can call it a contract between a client and a lawyer. Then drafting pleadings for the complainant. So I'm sure that in civil procedure, we all learned what we call pleadings. So pleadings are provided for by the civil procedure rules. And if you have looked at Plaints, what they have is what we call pleadings. And basically, when you look at Order 6 of the CPR, that is the revised acts, the revised CPR rules, they take you through of how you can draft pleadings. Then also institution of civil suits. We also looked at various modes of instituting suits. We looked at a plaint. We looked at notes of motion, chamber summons, and originating summons. But for purpose of this workshop, our major focus will be, I think, a plaint and some other modes of instituting suits. So workshop 1, introduction. So the workshop will deal with conducting successful client interviews, taking instructions, determination of parties and causes of action, institution of suits, and drafting pleadings for the complainant. So learning outcomes, by the end of the workshops, you'll be able to, 1, explain the options available to resolve the civil disputes. Of course, these learning outcomes are very, very important because the PA expects you to have understood or have an idea of at least all these ones by the end of the week. So when we talk about explain the option available to resolve civil disputes, we have a lot of modes where disputes can be resolved, and most especially these are alternative dispute resolution mechanisms like mediation and arbitration or reconciliation. So these are the options available to resolve the civil disputes, which we shall be looking at here. Then 2, determine the appropriate action to be taken in resolving the civil disputes. So the appropriate action to be taken in resolving the civil disputes, this could include 1, notice of intention to sue, drafting plaints, and all that. So those are the steps necessary steps that must be first be taken for you to institute a suit, which of course can begin from interviewing a client, having an engagement letter, then drafting a demand notice, then also drafting an intention to sue. So those are the course of actions we shall be looking at. Then of course illustrate the process of institution of suits. We shall also look at that, how do you institute a suit. Of course, notice of intention to sue, then drafting an orderly plaint, payment of court fees, issue and service of summons, then filing an affidavit. Those are things we shall be looking at. I'm sure that if you've been working with a law firm, then these are not new words to you. Then 5, draft the documents in relation to the institutions of the suits. So these documents I'm talking about are the ones we shall be drafting now. A plaint, a notice of invitation to sue, and also affidavit of service. So we go now to workshop facts, part A. So they are saying that the government of Uganda started a program called Operation Wealth Creation, intended to uplift household incomes of its citizens. Through this program, the government would, among others, distribute coffee seedlings to various farmers in selected districts. The coffee seedlings project was implemented by Uganda Coffee Development Authority in conjunction with the various local government officers, including those of Operation Wealth Creation. Several coffee nursery operators enrolled on the project, and each signed contracts to supply coffee seedlings to the selected farmers in the selected districts. Coffee nursery operators supplied seedlings as allocated in the list hereto attached and marked A. So that's an annexure which is marked A. So a one Topista Nasuna was contracted to supply for 450,000 seedlings as per the purchase order hereto attached and marked B. She made deliveries as per distribution form, which is called annexure C. So annexures, these are documents which are attached, which are attached to as proof. So basically, this is the proof that you will use to go to court, and you can also refer to it to get some other evidence. So Topista hired an Isuzu truck registered in the names of Kabiswa Godfrey, Fuso registration number UAT, being driven by Batio James to deliver her seedlings to Gomba on 20th October. After delivery of the seedlings, and as the driver was returning to Mukono, the truck was involved in a serious accident at Mpigi town. It knocked Johnson, a border rider at Mpigi police stage, who lost his right arm and is currently hospitalized at Chirudo Hospital in Kampala. The border which he had recently bought at Uganda Shillings for 4.5 was written off. Johnson can no longer ride a border where he was earning at least Uganda Shillings per day. The hospital bills at Chirudo have so far accumulated to Uganda Shillings 2.3. So basically, these facts raise a cause of action, because we see here that after delivery of the seedlings, as the driver was returning to Mukono, the truck was involved in a serious accident at PG Town, and it knocked Johnson, a border who lost his right arm and is currently hospitalized in Kampala. So the only way we can sue for this, when you look at the Miscellaneous Provisions Act, it provides that you can bring a claim where someone is injured or maybe he dies. So the only way you can acquire monetary compensation in civil litigation and where there is, for example, a fatal accident, or where there is maybe a very dangerous harm to the body of a person, is you proceed under that Miscellaneous Provisions Act. And you have had in instances whereby, like for example, buses have knocked down border guys. So you don't, yes, criminal proceedings would be instituted, but you know that the purpose of criminal proceedings is not to benefit the parties, but they are more of punishment. So you can also bring civil suits under the Miscellaneous Provisions Act, and that would be the cause of action, but then you have to prove that there was negligence. So basically here we shall be suing under that act. And previously it was section 5 and section 6. I don't know whether it was revised because I have not looked at the new act, but I think you can really based on that to come up with a discussion on Saturday, and also going to help you with your law firm. But since this person was injured, so you can sue under the miscellaneous provisions for causing harm to his body, and then you can be able to obtain all these. You can be able to obtain all these costs and damages I'm seeing here, but you must prove negligence. So since the deliveries were made on 20th of October 2023, UCDA has not made any payment to any of the operators. When Nansona contacted the managing director, Gube Andrew, for payment, he informed her that the office carried out an investigation a year after delivery and found out that about 50% of the suppliers made by farmers was air supply. There was no coffee plants found growing. The fraudulent action would put the authority at risk of losing taxpayers' money, which is likely to cause problems to the staff of UCDA. It could easily lead to prosecution under the Anti-Corruption Act. So basically here, the examiner is trying to put you astray, because you remember we are dealing with civil litigation. We are not interested in criminal proceedings. So you have to know, because here for me I can see a contract which was breached. So that means here the cause of action is the breach of contract. So the operators have made several complaints to UCDA, but the principal accountant, Mr. Godfrey Egeza, informed them that nothing much can be done given the report of the verification committee. He informed them that if they are willing to take half of their claims, UCDA would pay subsequently. While Nansona on 20th January 2024 borrowed Uganda shillings 10 million from a money lender, Batwenda Daudi, resident of Mukono municipality, the amount was lent on an interest of 20% per month for a period of 6 months, and Nansona anticipated that if she paid by UCDA, she would clear the said loan. To date, UCD has not paid despite several reminders. The said loan was secured by a simple deposit of the land title, Brock Plot 40, where Topista Family House is situated. So here they are taking us into, of course, land, but you have to also keep in mind that this is civil litigation, because the examiner wants to confuse you. You have to stick to civil litigation. So basically, this paragraph introduces the prayers you can ask in your plaint. For example, the interest, so you can ask these ones from your plaint, and court will grant them to you. So husband, so as a young lawyer who was recently admitted to LDC, illustrates the following how you should formalize instructions. So I said you can formalize instructions by drafting an engagement letter. Of course, I said an engagement letter is like a contract between a client and all his law firm. So they put a consideration, confidentiality. So you will look at those things. It's more of a contract between a client and a lawyer. So B, assuming Annexure B, the purchase order form had the following clause: in case of any dispute or failure to make payments, parties should first resolve the matter using the alternative dispute resolution mechanism available before taking the matter to court. How would you resolve the grievances without going to court? So basically here, like the way we talked about alternative dispute resolution mechanisms, so that means the parties would first have to go for mediation and first try to mediate. And so when they try to mediate, they can either resolve the issue, and if it fails, then that's when you can go to what? To court. So basically, when a dispute arises, you first draft what we call renotes of dispute. So this renotes of dispute will just be informing the other party that the contract we signed, there have been a breach from your side, and therefore I'm calling you to appear on this date for mediation. So that's a notice of dispute. You are basically putting it to the other party that a dispute has arose and you want to meet on a specific date, so as you can try to mediate that very conflict. Then from the mediation, you sign what we call an ADR agreement, what you have agreed from your meeting. So task 2, using role play, how you would obtain additional information in order to effectively deal with the various causes of actions disclosed. So from my view, I found out 3 causes of action. One was causing injury to a person. This one is because you proceed under the Miscellaneous Provisions Act, and it's by plaint because there is negligence. And then also we talked about breach of contract. So breach of contract, you also proceed by plaint. Then I think those were basically the cause of action I identified. But you will have to interrogate this further and see whether, of course, you can find other causes of action. But for me, from what I have seen, that's what I can identify for now. But also we have a mentorship group. If you're interested in mentorship, then you can join us. You can contact me. It's a mentorship. We go much into detail to discuss these things in detail, give summarized notes, well-prepared documents. So in case you can afford our small monthly subscription fee, you can come and we share the journey with you. But also if you cannot afford, it's okay. We shall mentor you from where ever you are. So they are saying that using role play, how you would obtain additional information to effectively deal with the various causes of action disclosed. So you find that some facts do not disclose all the information. So basically here you're trying to role play like what happens in movies. You are asking a fellow student. You will assume to be the other party, then you'll be asking, do you have this evidence? No. What was the date? So you are asking the other colleague of yours in a role play to give you evidence which you think is very material to the case, but was not provided for in the facts. So so task 3, draft the necessary documents that would institute the process above before going to court. So we agree that we're going to go to mediation. So here we're going to draft basically a notice of dispute, and I say that a notice of dispute, we are telling the other party that a conflict has arose, and we are calling you on this date at this place to come and appear, and we mediate. Then after that, you will sign what we call an ADR agreement or mediation agreement, and basically this one you are putting down what you have agreed. So part B, let me hope we are together at that point. And in case you think that maybe I erred in law and I arrived at the wrong conclusion, you can correct me, and I will be glad to hear that. But as per now, that's my opinion, and I think I pray that you people, you understand this. It's very easy. It's very easy. It's not that hard. So part B, Chagaba Andrew, a USD Coffee Extension Officer for Gomba Matters, to that in July 2024, the managing director of USD, Mr. Kagube Andrew, visited Gomba district and met him at Ngando sub-county headquarters. They said Kagube was furious because of the alleged air supply of coffee seedlings in the district. He informed him at UCDA had made investigations and found out that the farmers who had received coffee seedlings do not have any coffee seedlings growing. He further stated that some farmers had similar national ID numbers while others were duplicated. The said Kagube informed the said Chagaba that he no longer wants to retain him as a coffee extension officer of the area and that he should stop working immediately. UCDA has not remitted his salary from July 2024. Chagaba made a written complaint to the Human Resource UCDA, but to date he has never received any reply. On 3rd August 2024, he lodged a formal complaint to the labor officer of Gomba district, Barije James, who told him that he will investigate the complaint and later give him feedback. On 16 September 2024, the labor officer summoned him to his office and informed him that he had investigated the matter and found out the actions of the managing director were justified and advised him to resolve his matter with UCDA. Task 4 illustrates the remedy available to Chagaba Andrew. So we understand that under employment matters, these things are governed by the Employment Act, and whenever there is a conflict between an employer and an employee, of course the first remedy is to utilize internal mechanisms, but after that then you can write a letter to the labor officer where you proceed by a complaint. Then from there you can also go to the industrial court. So basically, but from the facts we see that he has already wrote a complaint to the labor officer, so the next step would be to go to the industrial court. So the remedy available to Chagaba Andrew, since he has already utilized the first two, then he can now go to the industrial court. But you go and look into the Employment Act, the revised Employment Act. Of course, I have not looked at it. Then you will have an informed opinion in your Saturday's discussions. So the procedure for obtaining the remedy above. So of course, the remedy available to Chagaba Andrew, then the procedure for obtaining the remedy above. So the Employment Act clearly gives you the procedure. If you read the Employment Act, they will tell you that in a labor office you proceed by a complaint. Then industrial court, they also give you the remedy. You just read that section very well, and the procedure will be there. So see the necessary documents, if any, that would enable him obtain the said remedy. So here we have said that in labor officer you draft a complaint. So now they want you to which document are we going to proceed with what? Which document are we going to proceed to go to the industrial court? And of course, it's always a reference. When you read the Employment Act, they say that it will be a reference to the industrial court. And in most cases, this reference to the industrial court is made by the labor officer. But also, there are some steps that the employee can take in case the labor officer is not acting. But I want you to go and read the Employment Act, because the Employment Act really clearly explains these things. That in a labor officer you proceed by a complaint, then in the industrial court you proceed by a reference. So here the document I'm going to draft would be reference what? To the industrial court, because already this employee has already utilized the mechanism of going to the labor officer. So identify any issues that are likely to arise in handling your instructions in all the above tasks. So basically, when we talk about ISCO issues, we are meaning like things that are prohibited by the professional code of conduct. So all those things, for example, overcharging clients, for example, maybe not paying appropriate court fees, all those bad acts are the ones we call ISCO issues. So then note, students must familiarize themselves with the various procedures of obtaining remedies. Electricity distribution tribunal. So in the electricity distribution tribunal, we also proceed by a complaint, and you should look at the Electricity Act, I think, but it's a complaint. Then you also look at the tax appeals tribunal. What do you proceed with? You also look at the insurance appeals tribunal, and also the equal opportunity tribunal. What documents do you proceed with, or what's the procedure? Because in the IA, now the PA might bring a conflict that involves tax appeals tribunal, and you are required to draft that document. And if you have not looked at it, then it might be hard. So the succession plan, basically this succession plan shows you how the class is going to be conducted, and they saying that there are going to be a roll call by PA, which is going to last for 5 minutes. Then introduction and workshop by PA, which is going to be 10 minutes. Then checking students' preparation, which is going to be 10 minutes. So checking students' preparation can involve checking your notes and documents. Then preparation and discussion by students. Then after that, students are going to begin to read presentations, those ones who discussed and how, according to how you would have prepared as a firm. Then wrap up by PA. Then after the discussion, the PA comes and wraps up. Then we have group one task will take 20 minutes. Group 2 task will take 20 minutes also. Group 3 task will take 20 minutes, and group 4 task will take 20 minutes. So that's workshop 1, and workshop 1 is going to be handled on Monday by in your respective firms and in different times. So that's my analysis of workshop 1, and it's entirely my opinion. And of course, at the back course, the PA is the final person. Even if you don't agree with his or her opinion, you must make sure that you at least you understand what he's telling to you. So we shall keep on waiting the PA to give us the final position, as of course we are following. But this one basically is going to help you in research and at least understand what you are looking or at. So having said that, allow me to proceed to workshop 2. Workshop 2 will be handled, I think, on Wednesday or Thursday therein. So workshop 2, they are saying that the workshop is a continuation of workshop 1 and is intended on determine the suitable modes procedure of commencement of suits. So we looked at different modes of commencement of suits, and we will also look at them as there is a notice of motion, there is a plaint, chamber summons, originating summons, especially endorsed plaint. Those are the different modes of commencement of suits. I'm very sure we looked at those ones in civil procedure at our undergraduate. Then rules governing pleadings. The rules governing pleadings are in order. The rules governing pleadings, I think that in order 6 of the CPR, how you can draft pleadings. You go and look at the entire order 6. It will tell you how you draft pleadings. So if you, in case you don't know pleadings are those maybe paragraphs in a plaint. That's how simple I can put it for a layman. So the other thing is procedure for commencement of suits. We say the procedure for commencement of suits is always notice of intention to sue, then draft a plaint. A plaint is always accompanied by summary of evidence, then someone is file a defense and an affidavit of service. Then another thing is rules governing pleadings. We have looked at these ones in order 6 of the CPR, revised, I think, if I'm not mistaken. Drafting claimants pleading, the duty of plaintiff's counsel and the role of court. Of course, the duty of plaintiff's counsel, you have to serve summons, you have to pay court fees, you have to make sure that you file in time, all those ones. Then role of court, issue summons, to prepare hearing notice, then at the institution of the suit. So those are the roles. Those ones I think are very clear and straightforward. So it is intended to develop a learner in the 3 critical areas of knowledge, skills, and values. So the learning outcomes for this workshop 2, 1, we have by the end of the workshops, you will be able to 1, illustrate the process of institution of suits, 2, draft documents that will help you institute a suit in relation to the facts disclosed in part A of the workshop 1. 3, illustrate the duty of counsel for plaintiffs in filing pleadings and the role of court at institution of proceedings. 4, illustrate the process service of the pleadings in 3 above. So how do you serve pleadings? So you serve pleadings basically, of course, you attach the plaint summary of evidence and someone's file a defense, then you serve the other party, then you file what you call an affidavit of service. So then recognize and deal with issues relating to institution of suits. Paying, of course, there is paying proper fees. Then, of course, you have to serve summons. So, like we have discussed. So, workshop facts. So, using the facts in workshop 1 with the necessary modifications as is necessary. Assume that all efforts to resolve the matter with the necessary operators without going to court have failed. So now the mediation has failed. NASUNA together with the other operators have approached you to have the matter taken to court. It is presumed that all operators have the documents annexed B and C for the respective seedlings supplied as located. Each seedling was supplied at cost of Uganda shilling 350. So illustrate the claimants the course of action you would take to institute the matter to court and the role of court. So basically the course of action, basically here, of course, the first thing you have to, when you're given instruction, you sign what we call an engagement letter. But this one had initially signed it, so we're not going to repeat it. So you will have to do what we call a notice of intention to sue, where you are serving the other party. Then from there you will have to draft a plaint. Then from there you pay payment of court fees. then the court will issue summons. So basically that's a procedure that they want us to go through. So task 2, draft the necessary documents to help you institute the matter in court. So the necessary documents here will be notice of invitation to they will have a plaint. Plaint is always supported by summary of evidence, and also it's always supported by summary of evidence, and someone's filed a defense and an affidavit of service if you have already served. Then part B, assuming someone's filed defense were issued on 30th August 2024 by the Registrar High Court, Commercial Division, and the same approval. It means you had traveled to Mombasa for a family reunion, but only returned yesterday to discover the above. So when you look at the civil procedure rules, basically order 5, rule 2, they say that you must file summons within 21 days. So you are always required to file 21 summons within 21 days. So you have to look at that CPR order 5 rule 1 and 2 very well, because it's very clear and straightforward. But also then defense order 8 rule 2 provides that if you are served with summons, you must file a defense within 15 days after service of summons. But of course there are provisions that in case you are out of time, you can seek leave to either serve summons out of time or file a defense out of time, but you must be having a sufficient reason. So I think this one is already out of time, so you have to seek leave to file a defense out of time. So it illustrates the process of service of pleadings by the plaintiff. So serving pleadings by the plaintiff, basically you have your plaint and all the annexed summary of evidence, and you serve them to the other party, and then you attach the affidavit of service. Then task 2, draft the necessary document in relation to task 3 above. So that the necessary documents, in my view, I think it's an affidavit of service, because they're saying that it the process of service of pleadings by the plaintiff, then draft the necessary documents in relation to task 3 above. So you will have to draft a plain summary of evidence, summons file, a defense, and affidavit of service. Then succession plan, we have roll call by cessation plan. It's not succession plan. Roll call by PA, which is going to be 5 minutes. Attendance, that's called what we call the attendance list. Introduction and workshop by PA. PA will have to introduce the workshop, checking students' preparation, checking your notes and all that stuff. Preparation and discussion by students. So that means that this will be, I think, on Wednesday or Thursday. The students who prepare their task will have to present. Then wrap up by PA. The PA will come and do what and conclude. Then group 1 task will take 30 minutes, 1 and 2. Group 2 task 3, 30 minutes. Group 3 task 4, 30 minutes. Then we have the references and the cases which we should read or summarize. And please, we have a mentorship group where we go into detail of all the workshop. We summarize these cases and we give you summarized cases. We summarize all the notes and we give you summarized notes. We have Zoom calls. We have physical one-on-one where we get to meet in person and discuss. So please, in case you fail to understand, it's a very affordable monthly fee of 100,000. So you can help us. Then we also help you. And that's it for this workshop. I really wish you success from the bottom of my heart. This is my opinion, and I'm not the law, so I can also err in light of the fact that this is above midnight. So in case you have any issues, you will get back to me and we can discuss. So thank you for listening, and I wish you a blessed week ahead.